I'm very happy to see everyone here because David is competing with the Vikings game this morning. I'm very happy to see everybody here.
Who won?
Still going on, still.
17-7.
I don't know. So, anyway, oh, and the other little commercial thing I wanted to say is that there's a brat sale at Von Hansen's that property is doing. Yes, today. So you can't leave now, but you can after we're done. So, okay. So, the stewardship committee has been learning a lot of new things this year, and one of the things we have learned is that churches should or can help people more with wills and estate planning. And today we have David Jacobsen, the attorney who helped Craig and I with just that. And it was a wonderful experience, just have to say. So we are lucky to have him, and I am very grateful. So you're welcome. Take it away.
I normally don't use a microphone because my voice is generally loud enough.
Use it.
Use it?
Yes.
Okay, for the recording.
Yep.
Okay,
Thank
we'll do.
Yeah.
So, yeah, Paul and Craig invited me to come talk, but they did not tell me that I'd be competing with the Vikings game and a brat sale.
I know.
Oh my goodness.
Oh, David, just one other little thing. I have a clipboard, and I'm hoping that people can write their name and email so we can send out some follow-up stuff. So that's what this is going around. Sorry.
No worries. So, we're going to be talking about estate and gift planning strategies. So, I know it's one of those topics that not a lot of people want to talk about, but it's something I think people need to talk about. I'm going to try to click on here a little bit, but then probably also go over here because I have more notes. I'm not going to talk a lot about me. You can get a lawyer that'll take an hour to talk about themselves. Lawyers love talking about themselves. But I grew up Canyon, Winnebago area, went to the University of Minnesota, William Mitchell, graduated with no clue on what the heck I was going to do. 2009 was a crap job market. Met an old attorney in my hometown, moved back. Joined up with a few other older lawyers in Northfield, and I've been there ever since. Used to live in Farmington, used to live in Rosemont. Now Northfield is home. I'm married to a lawyer, which is fun. I don't win many arguments, I guess. That's the old joke. We have three awesome kids. Oldest 10 is playing his last ball game today. I'll make the last one. And then the twins are 8, so identical girls. Wow. So stay busy. As a firm, what we do, estates and trusts, that's a large part of our practice. We represent a lot of small business owners with their business needs, contracts, buying and selling small businesses, leases, all that other stuff. Real estate, a lot of our clients own real estate, either farmland, commercial property, residential property, help with that. And then that very select civil litigation, basically the clients that aren't crazy, those are the ones that I represent. No family law, no personal injury, no comp, none of that. Okay, so here's our roadmap. Here's where we're going today. So we're going to talk about what is estate planning, why it's important, how to start estate planning. We're going to do an overview of the estate planning documents, the frequently talked about documents. We'll dive in a little bit, we'll scratch the surface on tax and gift considerations, talk about a few helpful tips, and then I'll open it up to some questions. Okay? All right, so what is estate planning? So first of all, a plan. Definition of a plan is really to do something, a detailed proposal to accomplish a goal, right? So we want to generally manage, preserve, and transition assets either during lifetime or upon death. my 10-year-old son asked me what I'm doing today, and I told him, I said, we're talking about estate planning. And he said, what is that? And I said, well, broadly, an estate is your assets after you die, right? And so the idea is we're planning for where those go. It's a little broader than that. We plan during life as well. But why it's important? Because not everybody has an estate plan. Not everybody has gone through this thought process and come up with a solution for how it's going to work. Over 50% of Americans over age 50 do not have an estate plan. Also, anybody a baby boomer in here? Is that one or two of you guys? Okay. Pretty large generation. The numbers are staggering, the amount of wealth that is going to be transferred from that generation to the next. Relatively great time in American history to acquire assets and for them to grow. Every day I meet with folks that say, well, I bought my house in 1972. And I said, you remember what you paid for it? Oh, it was a lot of money back then. And yeah, it was $34,000 or something like that. And now it's $400,000. So planning is very important. Okay, so you guys are here. That's awesome. That's the first step. Okay? There's a lot of people that don't take any sort of step. There are a lot of obstacles to coming up with an estate plan. Time. I'm working. I got stuff going on. Cost. It costs way too much money. Thinking about their own mortality. Thinking about these big questions. It's confusing. You have some lawyer with a suit and tie. Most of the time I don't wear a suit and tie, by the way. Throwing around terms like inter vivos trusts and all this stuff. It's like, I just want it simple. That's what I hear clients say all the time. I want it simple. Lack of trust with attorneys. Some attorneys have a bad name, bad rap, and honestly, a lot of them have deserved it, to be fair. But there are good attorneys. There's good estate planning attorneys. The ones in this area generally are pretty friendly because they're dealing with people. They're not working in huge firms representing huge corporations. There are attorneys in those firms that do that, but a lot of the estates and trust attorneys that I know in this area, they're good attorneys. So, but that's a barrier too. Don't know who to call. Lack of willingness to discuss money. Oh my goodness! I had when I started, I generally see these older farmers, and we don't talk about money. We just don't. Kids have no idea what they have, what they don't have. Which I get it. It's a generational thing, but that's not a very good plan if the person on the other end of it doesn't know what's going on. So those are the obstacles, okay? So we're gonna try to overcome those obstacles, right? So we wanna identify goals, okay? And write them down. Making family members' lives easier. That is almost always the goal of estate planning. So they know what to expect. Sometimes it's you want to make a lasting impact for your community or family. Sometimes it's easy. It's, I'm giving everything to my kids. But some folks are fortunate enough that they can do more. Or maybe there's no surviving children. Or maybe there's gifts to grandkids. I mean, there's different goals for different folks. I always say I take them as I find them. Which what that means is my job is to help you accomplish your goals. Sometimes we're talking about minimizing taxes and expenses. Some people hear that probate's expensive. It can be. There's ways to avoid probate in certain situations. There's potential tax implications, estate tax, income tax, capital gains, those types of things. So what I would recommend is you think about those things. Write them down. It doesn't have to be real complicated. Just think about those. Gather information. Any estate planning attorney is going to want to know who your family is, what your goals are. So contact information for key decision makers who you want making decisions if you can. both during your lifetime and upon death. People, organizations, who do you want to provide gifts to? Important. And then what you have. You'd be surprised how many folks I meet with that were going through their assets and they say, I don't know. I don't know. Or like in my family situation, you could ask my dad and he'd have no clue. My mom's written every check for the last 40-some years. My mom knows it backward, forward. My dad doesn't have a clue. There's a lot of relationships like that. And it works for them until it doesn't, right? So that's why you talk about it. That's where you come up with this. Really important for attorneys to understand the full picture. All right, so finding a trusted estate planning attorney, referrals. You guys might have estate planning attorneys. If you haven't, referrals are a great resource. Word of mouth. Talk to people in your church. Talk to your bankers. Talk to realtors. Talk to your financial advisors. A lot of them have relationships. You can read online reviews, but my little caveat to that is the bar is low to be liked as an estate planning attorney. I am not doing anything really messy, right? I mean, I'm not in litigation, I'm not handling somebody's messy divorce. Like, people are happy. This is something that they've been waiting on forever, that they've talked about and put off. When those documents get signed, you should be happy. And hopefully the attorney walks you through that process and makes it easy. So, I mean, look at online reviews. If somebody says, this attorney never called me back, and you know, blah, 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 then maybe not. But otherwise, it should be pretty much 5-star. Avoid online forms. I have more detailed notes. I have a St. Louis student help me put the presentation together. Might have missed a few things. That's okay. So there's checklists. You can Google estate planning checklists. I'm sure there's tons of them. We have one on our website. What kind of information? And supporting documents is helpful too. So, for example, deeds to real estate, account statements for retirement accounts, bank accounts, policy information for life insurance, all that's super helpful to have. So my comment where she says avoid online forms, what I meant was avoid the free steak dinner, okay? Just do it. There's like this gap, attorneys are a spectrum, right? And so like the old mentors I had out in the rural areas, they don't know trust, wills. Clients understand wills, right? And they wouldn't charge much to do a will. But then their kids are gonna have to go through probate. And so then they charge, a fair amount for the probate on the back end. And that was one side of the spectrum. And you have other attorneys, they're mostly metro area attorneys, that do seminars. They do all these seminars. I realize I'm presenting to you today, but they'll offer you a free steak or whatever else. Come listen to us talk. And they scare you guys. They just really scare you that unless you have a revocable trust, the sky's gonna fall. And they're gonna charge you way more for that revocable trust that needs to be done. Now, at the end of the day, you're still getting value because you're taking care of this for your kids. It's generally a pretty good plan, and it makes life easier for the kids. But go with local trusted attorneys that your organization knows, your people know. That's my recommendation. I've had to clean some of those up too, where I've had farmers in my area that, they use the local attorneys for everything else, and then they pay like 20 grand for an estate plan because somebody bought them a free steak. Anyway, okay, so let's talk about just some basics. Key estate planning documents, okay? So the low-hanging fruit, the easy documents that we always start with, are the documents that actually benefit you, the person making the estate plan. Those documents, healthcare directive, power of attorney. So healthcare directive, fairly simple document. You can make it really complex. Authorized by Minnesota law, enables another to make healthcare related decisions for you. Those are broadly defined as basically any including where you live, and receive care when those choices relate to your health care needs, right? The whole idea is we're providing a decision maker in the event of an incapacity to avoid a guardianship. That's where the court gets involved, and it often happens where somebody has to leave their home, go into a hospital setting, need to be discharged, they don't have the right level of care at home, they end up going into some type of assisted living facility or nursing home, and they want their bill paid, and it's a referral to social services. So, and then oftentimes the county will initiate a guardianship. Anybody deal with one of those guardianship? They're not real fun. So the idea from a legal perspective is we're naming somebody to make decisions to avoid that. I generally say I don't care what those decisions are. There are some folks that are familiar with like a 5 wishes healthcare directive that has fairly specific decision making for your healthcare. You certainly can do that. The way I do it is I have boxes you can fill out if you want, but mostly I'm saying you need to name an agent and a backup agent to make those decisions and guide, give them whatever guidance you want. You can put in burial, cremation, donation, pie cards, those types of things are often put into healthcare directive. Okay. Power of attorney is similar to the healthcare directive. It enables another to make financial decisions, pay your bills, handle your financial affairs while you're alive and under an incapacity. That person is called the attorney in fact, avoids conservatorship. So Minnesota has guardianship, conservatorship. Can be broad or you can limit it. Generally for estate planning purposes, we want powers, enable the attorney in fact to be able to file tax returns, make collections on retirement accounts, otherwise pay your bills. Right? Power of attorney, really good tool. There's reasons we do it. I give a short sermon, generally, short. When I have folks in talk about power of attorney, it is somewhat a license to steal. It gives somebody a power over financial accounts. So you want to name, first of all, the right person that understands it, and that person should seek advice if they have to step in, both legal or tax. Make sure they're doing what they're supposed to do as a fiduciary, dotting the I's, crossing the T's, not writing checks to themselves, all that stuff. So generally, the right people that are named, it's not an issue, especially if you're working with a trusted lawyer who understands what you're doing, you communicate well with your children. But there are lots of fights over this. It plays out where one sibling is here, one sibling is not here, the sibling here is taking care of mom or dad, and writing lots of checks, and including those checks to him or herself, while the other party isn't there. I'm doing the work, I should get compensated, and you can run into issues, lots of issues there. Okay. Okay, so these slides, I don't love the way they're put together, I'm being honest. But let's just talk about this. So upon death, so the power of attorney and healthcare directive, those powers end at death. So they're there for you. So upon death, there's lots of ways that assets pass. In the whole world, we can cut it in half. We can have probate world and we can have non-probate world. Okay? So probate is essentially assets trapped in a decedent's name, $75,000 or more, or any interest in real estate. Okay? So if you own a bank account with your spouse, joint bank account, one spouse dies. Let's say even there's $100,000, you're not going to need a probate because it's jointly owned with right of survivorship. The surviving spouse owns that account. Now, when that surviving spouse dies, now you're going to need a probate, right? Because we got $100,000 owned by the decedent alone, and we're going to need a probate. Ways to avoid probate, lots of ways. Direct transfer is probably the one that most people are familiar with. You got a joint bank account, or you have payable on death beneficiaries on that bank account or retirement account. Those are called direct transfers. So no probate needed. The decedent is named on the account with the institution that's holding it where those assets pass upon death. That works really well. It's fast, it's efficient. Doesn't end up going through probate. Has limitations. Those limitations are you anticipate that your beneficiary is going to survive you, which doesn't always happen. I mean, if it does, it makes it a lot easier. But if they don't, then it might be time to revisit the plan. So there's not a lot of contingencies on that, especially, just play this out. You have a couple kids that are, my age, 40, starting to show a few gray hairs due to their kids. And you name them as payable on death beneficiaries. Well, that works pretty well, assuming they survive it. But if they don't, now you got minor grandkids, right? You want the grandkids to receive their parents' share, so they step in your shoes. And then you may be able to convince somebody on an UTMA, uniform transfer of minors account, and set up a custodian. Otherwise, sometimes they need to set up a conservatorship and everything else, because you got grandkids receiving assets under 18. So generally speaking, those direct transfers work well, but there are limitations. The other way you can do, the other direct transfer, way to do a direct transfer is now. Give away what you have. And I know some people, holy cow, we didn't know we were going to talk about that. That can be a really good tool if the person who is making the gift, one, has the ability to make it, doesn't need the asset, they want to make sure that that asset gets to the next generation. Lifetime gifting can be an incredible tool. Okay, but it's got to be the right asset too. I'll cover that later. So as far as what you can do nothing. I mean, half America doesn't have an estate plan. They're doing nothing. So what happens there? You have, Minnesota has intestate succession laws. That's the legislature writing the statutes that say where your property goes when you die. It's probably similar to where you think it's going to go, but big problem if it's a second marriage. I mean, just being honest. Like, most people don't know what the default rules are for a second spouse. So that can get murky. When you have kids from outside the marriage, that's where it really gets tricky. So you have I think blended family, is that the common nomenclature? You have that, should have a good estate plan. Should talk through some of this stuff and not rely on the default. The pros, doesn't cost anything to do nothing. It's really easy to do nothing. You avoid decisions. There are some pros to it. Generally for the person that's making the decision to do nothing. The cons are for your family. I mean, that's really what it comes down to, is there's no plan. They just have to figure it out. And that generally requires time, money, emotions, and potential conflict amongst multiple people. All right, so everybody here has heard of a will? Yeah, okay. Most common estate planning document. Everybody knows what a will is. They at least they think they do. They've heard of it. So a will is a written document that leaves the estate of the person who signed it to name persons or entities. It says where your property passes. A will, I had a professor once say, a will is a letter to a judge. And that's what it means. A will doesn't mean anything unless it is probated, meaning submitted to the probate court, a judge interprets what the terms are. So the will is over here in this world for probate, okay? Pros, easy, generally inexpensive. The testator, that's the person making the will, retains control during lifetime. So it only provides for where assets pass when you die. Can you get one online? Yeah, you can. Is it going to be right for you? Maybe. I've seen pretty bad results with wills online, because I guess I'll just say this, the will is a commodity. I mean, it's a document, right? If you get it online. What we do as estates and trust attorneys is provide a service. We talk through what your goals are, we come up with a plan. The plan is the output. And so the idea is the will is just one piece of that plan. So I guess that's the way I look at it. I'm sure there's other people who look at it differently, but having a will is probably better than not having a will, but I would recommend you have an actual meeting with attorneys to discuss and work through this.
Question?
Jump in, Craig?
So what's the role of an executor? I've heard that.
Yeah, good question, I got you. Okay, so oftentimes in a will, you say where your property goes, and you name somebody responsible for administrating the estate, right? In Minnesota, we use the term personal representative, but personal representative is synonymous with executive. That is the person that you name that hopefully survives you to fulfill the estate obligations, which generally it's going to be inventory the assets, pay the bills, the valid debts, funeral expenses, last illness, all that stuff, file tax returns, do an accounting, and then make distributions to who you provide for in the will.
Then what is the role of probate in that? Why can't the executor just do it all?
Because the will doesn't mean anything unless a judge appoints, right? So you can name an executor, but that executor doesn't have any actual power until the will is submitted to the probate court. Yeah. And so who you name has priority under Minnesota law, but they may not be the qualified, which, I guess if I think about it, I name somebody that, a convicted felon and all this other stuff, and there's people that are like, I don't know if he should be, and they contest that. I mean, the court's going to appoint who's qualified, but generally speaking, priority is going to be who you name. Okay, so the cons of a will, generally on the back end, more time, money, requires probate for the family member. It's public, all those filings are public, and it's generally not a very good plan if you're going to do unequal distributions, okay? And so what I mean by that is, if it's equal shares to my kids, no big deal, right? Nobody's gonna fight over that, or they might. But where you really run into issues when you go 80-20 or something like that. And the reason why a will's not that great of an idea for that is because you file the will with the probate court, and under Minnesota law, you have to give notice. You have to give notice to the people named in the will, but also the people not named in the will. So if you're disinheriting folks, if they are interested persons under Minnesota law, they get a notice that somebody has filed for probate, even though they're not getting anything. So if we are limiting gifts, we almost always try to do it outside of a will or probate. And of course, you can do non-contest clauses and different things like that to try to mitigate and deter some of that, but it doesn't always work. Okay, so I already kind of talked about this, but this is direct transfers during lifetime. So this would be transfer specific assets to specific people. Pros, cons, I mean, it's inexpensive, it's easy. You're certain that the beneficiary receives the asset, possibly tax deductions. But the con is you no longer control it. So.
I have a question on that.
Yeah, fire at me.
Aren't there potential repercussions of that if, it can be come after by the government? Should, he needed to cover other expenses or something like that?
Yeah, so can I repeat that back a little bit? Are there repercussions to lifetime gifting?
Yeah, if you...
Yes.
Yeah.
100%, yes. So I think you're probably going toward long-term care and medical assistance, which I'll touch on just a little bit. That's not a specialty of my practice. I mean, being honest, most of my clients have resources. There are attorneys that specialize in this. So I'll give you kind of the 10,000-foot overview. Long-term care, it's paid out of three pockets: yours, the government's, or an insurance policy if you have a long-term care policy, right? Most people, they're paying out of their own pocket for long-term care services, right? So you budget for it, and you pay for it, and you reduce your assets by that. If you're gonna get the government to pay for it, you have to be indigent, poor. You have to spend on your assets to certain levels in order for the government to start paying for your medical assistance. Gifting is a big problem. There's a 5-year look back on that for any gifts of less than fair market value. So if you're going to gift, you need to have a good plan on that to gift and make sure that the beneficiary understands that you're gonna be ineligible for medical assistance benefits for 5 years from the date of that gift. Most of the time when I'm doing gifting, it is for folks that will never, ever qualify. I mean, they're right at the Minnesota estate tax exemption amount of $3 million. They're trying to reduce estate taxes, that's when they're doing gifts. Sometimes with family farms and things like that, they want their kids to have it, they're gonna do it now while they're alive, while their kids can operate the farm. There's always issues with that too. I mean, I have the farmers come in and say, I don't want the nursing home to take my farm. Well, the nursing home's not taking your farm, right? I mean, you're paying for whatever service you need, but in order for the government to pay for it, yeah, they can certainly lien it, if the government's spending taxpayer dollars. But the problem with that too is oftentimes you don't get the adjusted basis then. And then for capital gains tax, if your kid were to ever sell the farm, I mean, you could have a lot more tax. But at any rate, I'm probably getting off topic a little bit. Good question though, but here's what I'll say on gifting. And I got way more on gifting too, indirect gifting. Talk to your accountant, talk to your attorney before you make any gifts over $18,000 a year. Okay? All right. So direct transfer on death, we kind of talked about this. Most common is payable on death. Retirement accounts, especially if you have financial advisors, they're going to say, list beneficiaries. Do that and confirm those beneficiaries. And then also, if one of those beneficiaries passes, review that. Make sure that you have it the way you want it to go. This is generally the recommendation for retirement accounts, even if we have a trust, even if we have another way to avoid probate, and that is generally for income tax reasons. So easy, inexpensive, one retains control during life, avoids probate, and whatever it is generally revocable. Cons, it just lacks that flexibility. So if somebody dies. The other...
Question.
Yeah, go. All right. Sean, hey.
I am wondering about, I think all of us here are concerned about getting older and, having to go into some sort of a assisted living or a nursing home. Process, because we've just been through this with Jim's mom, is the Medicare part, right? So if you can't afford, you're on Medicare or Medicaid now, they take your assets. I mean, they will make you spend down everything, and she had a significant amount of savings. Luckily, we hired an attorney to take care of it, but what are some other ways to avoid that where you have these things planned, like a will to give people, portions of the income that you've worked so hard for without the government taking it?
Yeah, and I think it's how you look at it, right? Like as far as what you can do, you can give everything away and be poor and then go on government welfare. That's the plan. Medical assistance attorneys are going to tell you that's what we do. We create a plan for gifting. We budget for the next 5 years. The kids are going to pay some of that with the assets that have been gifted. That's really the plan. There's no government welfare benefits for millionaires. It just doesn't exist. So there are very strict rules on that and how it works, which, I mean, we all kind of should agree with too from a public policy standpoint. There are rules, there are strategies on how to do it, but in a nutshell, Sean, that's how you do it. You gift everything you have away, you create a plan to pay for it, or if you're young enough, you take out long-term care policies to protect against that risk. The other option, and it's not always feasible, multi-generational households. I have had 90-year-old ladies living out on farms that never could take care of themselves, but they have somebody just down the road. They have a son or daughter right down the road. Check on them, get them up in the morning. Family members doing a lot of this stuff, which significantly reduces their likelihood for ending up in a skilled facility for a long time. And then there's also home health too, which that's a little bit different under the elderly waiver, but generally less expensive than full-blown facility.
So if you have a significant amount of assets and you want to be able to pass them on to your family, is there some sort of a trust that you could put that into? That if you need to be a little more liquid, that you could pull some things out of it?
For medical assistance, no. If I could draft a trust that you get to have your cake and eat it too, on that, it would be crazy expensive. It doesn't exist. And there's other states where it might be more palpable, but Minnesota has a statute that says we do not care. If you get any sort of benefit from this trust at all, we're looking right through it for your assets. It's void against public policy, any sort of trust like that.
Yep.
Go for it.
I think the thing we're not thinking about is, ultimately, when you earn your money, that's to take care of yourself.
Right.
Our children are off, nobody's entitled to inherit from us. The biggest way to prevent any of that is ahead of time, get the long-term care insurance to cover it. Because otherwise, like with our grandparents, they had money, their money went to take care of them. We didn't look at it and go, hey, I can't wait, I'm gonna get, it just,
Yeah.
we take care of each other, you're taking care of yourself so that somebody else doesn't have to pay the cost. That is one benefit we do have here, is if they spend all their money and they can't take care of themselves, the government does step in, and us as taxpayers help take care of everybody else's parents who aren't paying for themselves too. So that's the flip side. I mean, I know we all would love to have an inheritance, but it's not always feasible. But upfront cost is the way to go with a long-term care plan.
How expensive is long-term care insurance?
It's expensive.
Yeah.
It depends on when you apply to.
Yeah.
Right.
Yeah, it
Start
really
start
does.
now.
Yeah.
Right.
Yeah. Go for it. In the back, sorry.
Yeah, I was, two points. One was, we took care of my mother, and longevity is a big issue with our generation and the greatest generation. My mother was in World War II with my dad. She lived to 94, blew through all of her assets, and went on medical assistance and elderly waiver here in Minnesota. She could still get her pension, and she was lucky to have health insurance through my dad's bank as a part of her pension. But what she says is a good point. We started, because of that experience, we started long-term care insurance 20 years ago.
Right.
And what they allow us to do is the premiums every year or 2 years, we can adjust the premiums based on how much we think we're going to need going forward.
Right.
So as we age, we don't expect to need 15 years of long-term care. We may be lucky with 5 or 10, I don't know. But there is flexibility within that long-term care. If you start early in your 50s and you pay lower premiums, you can, at least depending on how it's set up, you can adjust those premiums based on how much the value of it.
Right. The other thing too is 5 years is really the number you probably want to be tracking, because if you know that you have a long-term policy that's 5 years, you have these costs that you're going to be incurring, that's when you start gifting. I mean, so the medical assistance attorneys, I mean, they can give you really good advice now, but where they're worth every penny of their specialty is, I have a diagnosis. I have Lewy body dementia. I have whatever it is, where you know these costs are going to be coming, they can create that plan. Sometimes it's too late though. I mean, without that policy is really covering that 5-year gift window, where you can make those gifts and then be covered under that policy and then apply for medical assistance. If you guys have more questions on this too, there are some good attorneys that might be willing to come and talk to you guys about this stuff too. I have a few referrals that I do outside the metro area, but there's a couple really good ones here too in the South Metro. So, okay, I'm gonna switch gears a little bit. I wanted just to talk as far as direct transfer upon death. Transfer on death deed, anybody heard of that? Okay, that's a really interesting tool. So that's pretty new as far as Minnesota laws. I mean, this one didn't go back to 1850s. 2008 was when that was adopted. And it essentially allows you to transfer real estate the same way as like a bank account with payable on death beneficiaries. So you just name your kids if you want them to have the house. It can be a really good tool if you have 1 kid or 2 kids that they each have their own home, they're gonna clean it out, they're gonna sell it, and then split the proceeds. So you can avoid probate, you
I mean, you can do a will, or we generally do a will as a backup too, but the idea is you're looking at transferring all your assets, not via will, not via trust, payable on death beneficiaries, and transferring death deed for real estate. Works pretty well. I mean, again, the limitations, they gotta survive you, they gotta get along. If you have 3 or 4 or 5 kids, don't even think about it, that's a bad idea. It's gonna be bad, I promise, because you know one's gonna move back in to take care of you, live in the house, the others are gonna say, it'd be nice if you left, so we could sell the house. Of course, that's the kid that isn't married, without kids, without a job, and that makes it real fun. But it can be a really good tool in the right situation. Okay, so I want to talk a bit about trust. I know I'm going to go over time. I want to save some for questions. Okay, as far as trust, just quick overview. Just dispel everything you know about trust, because there's so many different types of trust. It's all confusing. Just trusts are an agreement. Just know that it's a 3-way agreement. Settler sets it up. Trustee is the one holding the assets. Beneficiaries are the one receiving it, right? Goes back to England, church. Church is how we got trust. We give people who had money and land, gave money to somebody else to hold for the benefit of the church. 3-way relationship, right? Okay, there's irrevocable trust. Can't change it. Once it's in place, done. No control. Revocable trust, like you might think, you can change it and you're in control. Inter vivos trust, during your lifetime. Testamentary trust, created upon death, okay? I'm gonna focus revocable trust, inter vivos, revocable living trust. That's a big one, okay? Testamentary trust upon death. Perfect example, minor kids, okay? So I have minor kids. Everything that I own with my wife is set up, it's going to her if I die. We each have a will with the trust in it that says, upon the death of the survivor of us, it goes into a trust for the benefit of our kids. Name, guardian, designations, all that other stuff too. Irrevocable trust, oftentimes this is for the wealthy, where we're trying to do some estate tax planning with it, with an irrevocable trust. Okay?
Does that mean that the person putting the trust together cannot change it either?
Correct.
Yep.
Correct. Yep.
You know,
So that's why we're really careful about what assets go in it and why we're doing it.
yeah, my father took his house, is paid off, and put it in my name and my brother's name.
Yep.
So we both have it, so
While he was alive.
while he's alive, yeah.
Direct transfer, there you go. That works.
Yeah, and he's been talking to us about, you know, like he has a Harley and he wants to do all this, and I'm like, Dad, you just need, it's complex, you just need to go talk to an attorney that you trust. That's hard to find.
It is, it can be, it shouldn't be, but it is. Yeah, so I'm in Northfield. Northfield's 20,000, college is cows and contentment. That's our motto. There's, I think, 6 full-time attorneys in Northfield, maybe now 7. I think there were 15 or 16 when I started. At least the rural areas of Minnesota, there are a lot less.
Yeah.
Because the cost of law school is crazy, and they want to work in a big firm and make a ton of money. Or the corporate world is getting bigger and bigger. There's more complexity, and there's a lot of attorneys working in-house with companies, doing compliance and regulation and everything else. So I don't want to say it's a dying industry, but if you can find ones that are good, keep them. Because it seems to be, there's less and less. All right, so written agreement, settlers, person setting it up, other person called trustee, so I covered this. Trustee holds property for the benefit of the beneficiaries, which can be either persons or entities. So this is your revocable living trust, signed by the settler, provides for management of property. Pros, settler retains control during lifetime, you can change it, you can add a name, you can take a name off, you can revoke the whole thing, or whatever, completely can be changed. You can narrow distribution to 1 or more children in property. It is by far the most a flexible estate planning tool. You can provide for descendants of children, so if you have 1 kid pre-deceased, you can have it go to your grandkids in trust until they hit 23, 25, 27. There's just a lot more flexibility than the payable on top. Cons is generally more time and money on the front end. A good estate planning attorney that does a lot of these is going to be a little bit tough on you about getting account statements for all your assets. The reason why, the whole idea of the trust is it needs to be funded, meaning you set it up, you create it, then you have to put your assets in it to make it work properly and avoid probate. So it's a little bit more work on your end to get all that stuff together, that asset inventory with the documentation, and then work with the attorneys to fund it. That other thing too that bothers me in my profession, I don't want this to be like a therapy session where I complain about lawyers, but it bothers me when attorneys draft these trusts and they don't help you fund them. There are some that just, it's a big binder and they just throw it at you and say, fund the trust. We can't do that. I mean, I have so many clients that are in their 80s or 90s, like they need guidance, they need help on this. Your clients need to have a letter that says, bring it to the bank, this is what you give them, this is what needs to be done, confirm it in writing and bring it back to me so I can make it a part of your file that goes to your kids as well, so they know what assets are actually in the trust. Inventory is super important, so anyway. Okay.
Does a revocable trust become irrevocable upon death?
Yes.
Okay.
It actually becomes irrevocable upon disability too. So a lot of times the way I draft it, it says if I'm incapacitated, I can no longer make changes, and if I die, it no longer can make changes. Yep. So it becomes an irrevocable trust at that point. You have a successor trustee that you name that steps in and administers it, pays the bills, gathers the assets, pays tax returns, whatever's there, and then makes distributions to the folks according to your wishes, or hold it in trust for minor beneficiaries or whatever terms and conditions. But you can get really specific. If you want to control beyond the grave a little bit, revocable trust is what you want here. Farms, great tool. You want to provide options to kids. Like, I want to give my kids an option to purchase this. Cabin trust, they work well for cabins. But the idea is you create this framework and this plan for your assets to kind of survive beyond your death for your beneficiaries, and you can control the terms and conditions. Okay, any questions on trust before I just fire over and start throwing some tax stuff at you? Okay. All right, I'm at 11:30, I'm going to 11:45, right? Got it, okay. All right, so state tax Minnesota, $3 million per individual. This is where I lose a lot of people. Anything under $3 million passes to your kids without paying any estate tax to Minnesota. There is a federal estate tax, which kicks in at $13.62 million, which must be nice. It's historically high. And the reason I bring this up is because you think, well, I'm nowhere near that. It's going to sunset. I don't know what's going to happen in November. It will sunset though. It'll go to 7. What sunset means, if anybody knows anything about how laws are created in Congress, what it means is there's a timeline to that bill, which means if Congress doesn't act, it's done. I don't bet on Congress acting on anything today. So that's just my view. So it's going to sunset to about 7. Now on the federal side, you have portability, which means married couples basically can get $14 million. Death of the first spouse, everything rolls to the second spouse. Second spouse dies, kids fill out the estate tax return. Yes, this decedent had over $7 million, but their spouse died previously, and we get another $7 million from their unused exemption. So you can tack on that. They call that portability. Minnesota does not have portability. If anybody has the ear of a representative, we can talk about that, but it'll never go. It just won't. It's not tax neutral. It would be nice if it was that way for planning and make life a lot easier, but we don't. So it's a 9 to 16% tax on anything over $3 million. You have to file a Minnesota estate tax return. There's unlimited marital deduction, so it generally isn't on the death of the first spouse, it's on the death of the second. But where we do a lot of planning is for my Minnesota rich clients. They have over $3 million, under $6 million. We can generally plan an estate tax of 0 with the right plan. We create separate trusts. We separate the assets of the clients that have been married for 45 years, owned everything jointly. I know it's hard to talk about, but we pull it apart. We put half the assets in husband's trust, half the assets in wife's trust. And then upon the first spouse's death, we don't have all the assets go to the surviving spouse unfettered. They stay in the first spouse to die's trust. The surviving spouse can still get income, can still get principal if needed, but there's a discretionary standard, so the Department of Revenue doesn't say all $6 million is your money. So then the kids actually receive out of both trusts 2 buckets, up to $6 million real estate tax. Requires a bit of planning. Okay, so let's talk a little bit too about other tax planning, income tax planning. Anybody heard of stepped up basis? Farmland? Yeah, okay. See a lot with farmland. I have clients, they have farms that they pay $500 an acre for. It's now worth like $13,000. They sell it during the election, they're gonna pay a ton of capital gains tax. Federal rate's 20%. Net investment tax on top of that, Minnesota income tax, 30%, give or take, on the gain. They hold on to that to the day of their death. Kids get a stepped up basis, meaning now if the kids sell the property and fair market date of death, value is their basis. So if they sell it 3 months after mom or dad die, zero income tax. Hold on to farmland. We hold on to farmland. Hold on to the old 3M stock that you got for $12 a share too. Those are the assets we want to hold on to. We don't mind paying estate tax if we have to, because I can almost guarantee you there's going to be less tax than if you sell it during your lifetime. So that's why you see people holding on to farmland forever. Let me see what else I got. A couple other things. So gifting. Well, let me talk about just some income tax planning too. IRAs, qualified plans, 401ks, all that stuff. It's kind of this unique thing now with, I would say, maybe baby boomers or Gen X, where we have fairly large, I'm seeing fairly large qualified plans. I think before it was more pensions, and now that's kind of shifting over. There's some really good income tax planning that can be done with these. Talk to your CPA. Get some good advice on this. What I see is after the Secure Act in 2019, beneficiaries that are non-spouses, they have to pull those accounts, they have to make distributions within 10 years, okay? So let's just run the numbers on that. There's $1 million IRA, 1 kid who mom and dad die in their 80s, kid's in his 50s, making $300K a year. Let's throw that income on top. That's a big number that they're gonna have to pay. So almost always it makes sense to start drawing down on some of those. I know it's hard because the retirement account, we never know how long we're gonna live, it's gonna be there. But there's some really good income tax planning that can be done if your CPA understands everything going on. The other thing too is if you don't need the income, you don't want to hold on to it because of that time bomb for your kids. You can figure out a way, it can be done, where you can take the distributions out at 72.5, you have your RMDs, and you can give those to a charity too. And that avoids the income act. There's some really good planning that can be done there. Benefits charities, also benefits you because you're preserving that. You're avoiding the tax. Spouse, they get to treat it as though it was theirs all along, just so you know. So the IRS looks at it as one unit. So same rules, 59.5, 72.5. Okay? So that's why even with qualified plans, a lot of times what we're doing is we're naming spouse and then kids as beneficiaries rather than the trust, unless we need to go to minor kids and then the benefits of the trust outweigh the individuals. Go ahead in the back.
Can you donate that RMD right to your church?
Yes, yes, and there's tax advantages to doing that. Talk to whoever holds your retirement plan, talk to your CPA, coordinated team effort. You can get it done, yep. It's probably a lot more tax advantageous than writing a check and putting it in the offering plan. Okay, so gift tax, gifting. So the folks that I have that are close to that 3 million or over, we gift. That's the secret. It's just what Sean's saying too, as far as stat gifting property. That's the secret, right? We gift. So Minnesota has no gift tax, so you can gift anything you have now to your kids without paying any tax. But all gifts are pulled back in 3 years from date of death. Okay, so no deathbed giving. You can gift anything you want, but if you gift it within 3 years, we pull that back in and add it on to get your $3 million, right? On the federal side, you can gift anything as well. If you gift it you're gifting anything over $18,000, you have to file a gift tax return. There's no tax paid on the return. You just have to document the amount of it. If it's over $18,000 per person, per individual, that takes away from your $13.62 million. Okay, so I gift $2 million today. I now have $11.62 million to give on my debt. Generally not going to be an issue for a lot of folks. So gifting is a really good tool. Talk to your attorney, talk to your accountant, make sure everybody's on the same page. There's definitely an opportunity for some good planning, but there can be a gap. If your estate tax attorney is saying gift, and your CPA doesn't know that you're gifting, that can be a big problem. So team effort.
So you can even give say a farm or a large piece of real estate?
Correct. The problem though, when you gift the farm, the kids don't get the stepped up basis when you die. They get your basis. But I have clients that have one farming error. Are they ever gonna sell in their lifetime? They better not, that's what I've been told. Well then, we don't really care. If that one beneficiary is gonna own it till they die, or gift it off to their kids, they're never gonna sell it. They will never incur the capital gains. So that is a good strategy too, yeah. Okay, just a couple of other quick ones here. There are other ways to do charitable giving too. So I talked about this before, distributions from a qualified plan directly to a donor advised fund or charitable organization. That's a really good planning technique. It removes assets from your estate before the total is tallied up. Or you can, and so you can do that directly, or you can do these are irrevocable trusts. They're a little bit more complex. A charitable lead trust or a charitable remainder trust. They're fairly complicated. I don't like irrevocable trusts, I'm just being honest, because they require administration, they require somebody to know what they're doing after it was initially set up, which generally means you have some third party that understands it, and that can be fairly expensive too. But if you're sitting on a fairly large estate, those tools can be done. Those can work. But it's not something we do every day. It's just not. But they exist. Just okay. And then charitable gifts, organizations are excluded from your taxable estate. So you give it to a charity or you give it to the government. Your choice. There's no limit to how much you can give, right? So if I have $5 million, my kids don't need that. I'm going to give them each $1 million. I have $3 million taxable estate. The remaining $2 million that would be subject to tax, I'm giving to a charity, right? That's a win. That's a win for them. It's a win for the charity. It's not a win for the government, but they're doing okay. Okay, so closing tips. If you get nothing out of everything I just thrown at you, estate planning is a team effort. It is 100% a team effort. It is estate planning attorney. It is your family. It is your CPA if you're doing gifting, your financial advisor. Everybody works together at that to get the best results, okay? Definitely had financial advisors that didn't know what I was doing, definitely had CPAs that I didn't know what they were doing. Getting on the same page makes life so much easier. Generally when clients walk out, they have a binder physically of all their original docs. They also have generally a photocopy, an electronic binder. Talk to your kids. Let them know what the plan is, let them know where they can find it, let them know what the assets are. The inventories that I produce, if I'm doing trust, here are the assets in the trust, here are the assets not in the trust. Hopefully we got account statements, here's contact information for attorney, advisor, funeral home information can be in there too. come up with a good plan, and it takes a team to do it. Okay, and then the other thing too is talk to your family. I know, some people don't want to talk about it. Talk to your family about your estate plan, clarify the roles. If you name your kid as power of attorney, they should know that. They should know where they can find the document, what their obligations are, and who they need to get advice from on how to do their job without screwing it up. Statements of values. What do you value in life? What are we trying to do with your estate plan? I think that's super important. Write a love letter to your kids. Write a love letter to your spouse in there. Like, make it special, right? Location of documents and recommendations. That's super helpful. Again, location of documents, who your folks are. List of passwords, access to electronic records. Really helpful. I have a file on my laptop that's called Muskrat. And that has all my passwords. There's a movie, it was 20 years ago, it's called Meet the Parents. And like the dad was Robert De Niro, and he was like ex-CIA. And he kept saying, Muskrat, like, be quiet, Muskrat. So, anyway. Have your contacts too. Estate planning attorney, financial advisor, insurance agent. Have those all together so the kids know. Super important. Okay. I did okay. All right. Questions?
Very good, yeah, we
I
know.
did okay for time.
You had a good stage there.